I'm very excited to talk to you today about the research being conducted at the law faculty and a bit about my work in particular. While the traditional study of normative aspects of law, carefully reading and interpreting legal text has always been and will continue to be at the focus of what we do, in the past decade, we have become a leading faculty in the newly emerging field of empirical legal studies. More and more of our faculty use advanced scientific methods, statistical analysis, experiments, computational textual analysis to answer traditional and new legal questions. To demonstrate this, I'd like to present some of my work. My work focuses on the questions of justices' considerations when they decide on a legal dispute. Few theoretical models answer this question. The first one is the legal model with the most obvious answer. What do justices take into consideration? The law. They decide according to legislation and to legal proceedings. However, recently we started to use empirical method and statistical analysis and to observe certain patterns in legal decisions. It started in the US Supreme Court, Federal Supreme Court, and we saw certain patterns where the appointing president's party predicted how a judge will decide. So justices appointed by Republican presidents tended to decide more conservative decisions, while those appointed by Democrat presidents voted more liberally. My work studies this model in the Israeli Supreme Court, and for example, this is one of my earlier studies where the pink circle represent religious justices, and you can see that the religious justices in the Israeli Supreme Court tend to decide more with accordance of the interests of religious parties in litigation considering religious right, while the secular judges represented by the blue triangles tend to decide less according to religious interest, and basically 50% of their decisions are for religious interest and 50% are for non-religious interests. In a more recent study, I used mathematical formulas to try and calculate and predict the ideological positions of justices in the Israeli court. And using these mathematical formula, we tried to compare the degree of attitudinal decision-making in 5 different Supreme Courts around the world: the US Supreme Court, the Indian Supreme Court, the Supreme Court of the Philippines, the Israeli Supreme Court, and the Canadian Supreme Court. Our results show that the US Supreme Court is by far the most political, the most attitudinal courts, where justices decide according to their ideological inclination to the highest degree. So what happens in these other courts? What motivates judges? We know that attitudinal consideration can explain some of their decisions, but not all. This brings me to the rational choice model. The rational choice model says that indeed judges are political actors, but they also take into consideration more strategic elements. So they're impacted by the view of the rest of the judges in their panel, but they're also impacted by the public opinion or the position of the parliament. So in a study testing this model, we focused on terror litigation, and we were able to show that in the days prior to a deadly terror attack, or when there's a war or an operation in Gaza Strip, the judges are less likely to accept petitions against the action of the security forces in Israel. And if and when they accept these petitions, it's more covertly done using compromises and decisions that are not published. This results, of course, show the permanence of this model in the Israeli Supreme Court. Another model is a new institutional approach, a new institutional model, and this model says that indeed both attitudes and strategic considerations impact the way judges decide, but the law still does matter. Maybe it's not a direct influence of the law, because the law is something fluid that can be interpreted in different ways, but the justices cannot and do not ignore what the law says. So in order to test this model and this theory, for example, we decided to test the impact of a new sentencing reform, sentencing legislation in Israel in 2012. We saw a great impact of this legislation, as these graphs show you. However, we were surprised to see the way in which the new sentencing legislation impact judicial decisions. So we were surprised to see that after the legislation, judges tended to promote more and more plea bargains instead of actually implementing this new sentencing legislation. We conducted some interviews with judges, asking them why they do that, and we were surprised to hear that the workloads of the judges had a great impact on their inclination not to implement the new legislation, but rather to opt towards promoting plea bargains where they did not have to actually implement the sentence. So they were so busy, and judges in Israel are indeed suffer from they're overworked from very high workloads, which actually brings us to the last model that I'm going to talk about, the cognitive approach. This cognitive approach says that judges are indeed influenced by their ideologies, they're political actors, they're strategic actors, and yes, the law does matter, but most of all, they're people. Judges are people, and like all of us, they suffer from biases, from cognitive biases. So, for example, the workload would affect the way they decide. In order to further test this, we've conducted a natural experiment in the Israeli judiciary. We tested the way judges decide before and after a reduce in their workload, where the reduce in the workload was granted to only some of the judges randomly selected because of a reform in the Israeli judicial system, where because of workloads, the new judges were appointed to perform trial by nights, a second shift of trials. So only some of the judges in Israel enjoyed a reduce in their workload. And what we found is this reducing the workload impacted not only the length of judicial decisions, or judges enjoying from a reduced workload promoted less compromises and written more actual decisions after hearing evidence. But what's most interesting is that it had an impact on what their decision was. So judges with reduced workloads tended to decide more in favor of plaintiffs, and when they decided in favor of the plaintiffs, they awarded them a higher percentage of their claim than judges that continued to be overworked. In order to do all these studies about judicial behavior, we need data. And with recent developments in textual analysis and the creation of big databases, I've just published a new data set together with my partner, my co-author, Professor Lee Epstein, where we actually were able to code using new methods all the Israeli Supreme Court's decisions from 2010 till today. And we made this publicly available not only for researchers, but for policymakers and for journalists and for anyone interested in the Israeli courts. We've started to see that there's more and more usage of this data set, and we hope it will further advance empirical legal studies and judicial behavior in particular. Thank you.